Ripple has won significant victories against the United States Securities and Exchange Commission (SEC) regarding the security status of its XRP sales. Nonetheless, there remain certain overhangs in this dispute. In particular, analysts have been paying a great deal of attention to the ongoing conflict that is associated with the institutional sales of XRP. By April 2024, it is anticipated that a decision will be made regarding the same. Recent developments in the Ripple lawsuit recently. Ripple and the United States Securities and Exchange Commission have been engaged in a dispute around access to financial statements and the detection of XRP sales. The Securities and Exchange Commission has requested that the court order Ripple to submit. This includes audited financial accounts for the years 2022-23, contracts for selling or transferring XRP to individuals who are not employees, and specifics regarding XRP sales, money received after the litigation was initiated. In the most recent update regarding the SEC's complaint against Ripple Labs, Ripple expressed its disagreement with the SEC's request for audited financial accounts, contracts linked to XRP sales following the lawsuit, and details regarding the money from XRE institutional sales. It was on January 19 that Ripple submitted its opposition. After some time had passed, on Tuesday, January 23, the SEC responded to support its request. The Securities and Exchange Commission contends that its requests for information about remedies are appropriate and timely. The document further states that when dealing with violations of securities law, the courts typically take into consideration the facts after the complaint has been filed. The strengthened legal posture that the SEC has taken against Ripple has significant repercussions, not only for the technology business, but also for the cryptocurrency market as a whole. It is possible that how Ripple defends itself in the outcome of this law will establish a standard for how the securities laws of the United States regulate and investigate other cryptocurrency companies. Changes in the XRP exchange-traded fund following the debut of a spot Bitcoin exchange-traded fund. Earlier this month, there have been rumors circulating about the possibility of a subsequent spot XRP. BlackRock has denied having any imminent plans to move in this route, despite earlier reports suggesting that the asset management giant was investigating the possibility of doing so. However, in the midst of the current dispute between Ripple and the SEC, market analysts have voiced a lack of trust in the possibility of a spot XRP exchange-traded fund being approved. Experts believe that the ongoing legal struggle between the United States Securities and Exchange Commission, Ripple, in addition to the lack of an approved exchange-traded fund ETF for XRP futures, makes it less likely that a spot XRP ETF would be approved. According to Townsend Lansing, the head of product at CoinShares, acquiring clearance for an exchange-traded fund that invests in XRP would be difficult unless the Securities and Exchange Commission is obliged to acknowledge or concur that XRP is not a security. In what way will the lawsuit between Ripple and the SEC develop? It is difficult to make an accurate prediction regarding the outcome of the lawsuit because of the lengthy historical history of the Rippleverse. SEC struggle, on the other hand, market professionals and analysts anticipate that the Ripple case will be resolved by the second or third quarter of 2024. An attorney who specializes in crypto law named John Detton argues that the SEC's legal conflict with Coinbase may have a substantial impact on the outcome of the Ripple case. Deaton thinks that a settlement in the Ripple litigation might be reached if Coinbase is successful in its argument and obtains a favorable conclusion. Coinbase submitted a request to dismiss the charges brought by the Securities and Exchange Commission (SEC) in October. The move challenged the SEC's ability to regulate the cryptocurrency industry and contested the classification of publicly traded crypto assets as investment contracts. Ripple X Supply, a significant player in the cryptocurrency industry, is currently battling with heightened legal scrutiny from the Securities and Exchange Commission (SEC). In this continuous drama, the most recent conflict is the Securities and Exchange Commission's stacked to strengthen its case against Ripple by filing a reply in support of its request to compel. The purpose of this legal maneuver is to gather essential financial data and respond to particular interrogatories from Ripple. The primary focus of this maneuver is on the company's audited financial accounts for the past 2 years, as well as specific information surrounding post-complaint institutional sales contracts. The recent action taken by the Securities and Exchange Commission SEC demonstrates the agency's steadfast dedication to pursuing this issue and achieving a favorable resolution. As a result of the regulatory body's partial win, earlier in the proceedings, XRP was classed as a security involving institutional sales. This decision indicates that the regulatory body has made its determination. Despite this, the Securities and Exchange Commission is not giving up on its quest for thorough disclosure from Ripple. This continues to demonstrate the SEC's tough approach to regulatory compliance in the cryptocurrency industry. The cryptocurrency industry is currently waiting for the final verdict about the reparations that the blockchain company is required to pay for its institutional sales of XRP. This comes after Ripple achieved several significant victories in the court case that has been going on for years against the United States Securities and Exchange Commission. Judge Annalisa Torres made a significant ruling on July 13, 2023, in which she stated that there were no retail sales of the XRP token that qualified as security sales. However, she did state that institutional sales did qualify as not. This leaves the two sides to attempt to reach a consensus on the amount of damages that Ripple is required to pay. Take a look. Come along with us as we demonstrate the transformation brought about by cryptocurrencies, one newsletter at a time. Join our millions of other subscribers and receive daily news and market updates delivered directly to your inbox by subscribing to our newsletter right now. Yes, millions of people believe in us. What exactly are you holding out for? Making gestures and providing responses according to a document that was published by defense attorney and former federal prosecutor James K. Phelan, the Securities and Exchange Commission submitted a motion to compel Ripple to furnish its financial statements for the period of 2022 to 2023, as well as its post-complaint contracts that control institutional sales within this context on January 11, following its motion for extension of time until January 19 to answer to the SEC's motion to compel. Ripple's legal team filed its response opposing it within the provided time limit. In this response, it asked the court to refuse the requests made by the government agency, stating that the requests were untimely and unreasonable. Within the context of the ongoing legal battle between the Securities and Exchange Commission, SEC, and Ripple, the regulatory body has responded by stating in a new court filing that Ripple's arguments are without foundation. Ripple's opposition to the request for audited financial statements and the presentation of contracts linked to XRP sales has been defeated by the Securities and Exchange Commissions. In its most recent filing, the Securities and Exchange Commission, SEC, refutes Ripple's assertion that the SEC's motion is untimely. The SEC explained that the pursuit of remedies related discovery is not time-barred and is a common component of violations of securities law. Ripple's argument that such information does not influence the judgments made by the court is refuted by the regulatory body, which highlights the importance of post-complaint facts in the process of deciding remedies. The CC's motion to compel has been submitted, which is a further support of the motion. Over Ripple's concerns over the disclosure of post-complaint institutional sales contracts, the Securities and Exchange Commission contends that these contracts are extremely pertinent to determining the risk of future violations. The regulatory body maintains that it is necessary to investigate these contracts to ascertain whether or not Ripple planned sales of XRP or by the summary judgment ruling issued by the Superior Court.